Hey, folks, James Abrinio here, and welcome to a newly named podcast, the Abrinio Cho podcast. It was formerly Abrinio Law. I just added my wife as a partner. She's my new boss, so that's the reason for the name change. But I wanted to thank a great guest today, Andrew Ward. I'm going to let you introduce yourself in a moment, Andrew. I really appreciate you coming on. He's going to talk to us about a really interesting case that deals with Virginia law, barrier crime. So, Andrew, really appreciate you coming on today.
Yeah, thanks for having me.
Yeah. So, Andrew, first of all, before we get into barrier crimes and the really interesting case that you were involved in, tell us a little about yourself. Tell us a little about the Institutes of Justice and just what you all do generally.
Sure. So I am Andrew Ward. I am a senior attorney at the Institute for Justice, which is a national nonprofit public interest law firm. We've been litigating against the government since 1991 in a few key areas. We work on school choice, free speech, protecting private property, and what's going to be relevant to this conversation, which is economic liberty, the idea that you should be able to go and work in, an honest calling, be able to support yourself, start a business without unreasonable interference from the government.
Yeah, and what I appreciate about you, folks that are watching this probably know I'm proudly call myself a lefty nut job. I'm very left, center, that kind of thing. You all, I see it really as a nonpartisan effort. You're really just trying to minimize impact by government overreach, and I really appreciate that. So
yeah, that's exactly right. I mean, like simplistically, right? If you were to think about the little 4-quadrant political diagram, like sure, we're libertarian in a small L sense, but honestly, nearly all of what we do is, I think, so commonsensical. Things that everybody can agree on, that you shouldn't be fined $30,000 for not mowing your lawn, that people who want to be able to do daycare shouldn't have to get college degrees. I mean, I don't think that's partisan. I think that's stuff that's sort of so commonsensical that left and right can all get behind it.
Yeah, and our mutual friend, who is a colleague of yours, Sam Gedge, he had a very interesting case with civil forfeitures, where essentially law enforcement will not arrest you, but they'll take the cash out of your car or take your car or whatever, and then just like not give it back. So I always found that comical, to say the least. But so first of all, what are barrier crimes? Tell us what we're talking about here.
Sure. So what the subject of a lawsuit that my firm brought is Virginia's barrier crime law. That is a law that applies to roughly 176, there's some counting issues, there's some stuff around the margins, but different convictions that will prevent you from ever, for the most part, working in certain fields. And in particular, if you've been convicted of any of these 176 crimes, there's likely going to be a lifetime ban on you working as a substance abuse counselor. Some of those crimes are things like murder. Some of them are recklessly driving a boat, or shining a laser pointer at a police officer, or negligently setting fire to a field.
And I've been doing criminal defense for 16 years. A lot of colleagues, I think, watch this. So part of the reason I wanted to bring you on is this is one of these things that we call collateral consequences, where if you're working out a plea deal, one of the things you have to be aware of, it may not directly impact or give leverage on a negotiation, but at least when you're educating your client about a particular outcome, they need to be aware that, a conviction itself has these downstream impacts that could potentially affect their ability to earn a living, to do what they want, that kind of thing. So
that's right. And there are so many of those laws that nobody even knows how many there are. Like it's in the 20,000s or so. You think about how much time you might be in prison. Maybe you think about immigration, voting, guns, but actually there are literally tens of thousands of laws like this across the country that will prevent people from working because of something in their past. Sometimes those laws make sense. Nobody thinks that like some drug kingpin should get to be a pharmacist or something like that. But a huge percentage of them are ultimately restrictions that just deprive the public of someone who's trying to work, and ultimately they contribute to recidivism because they stop people who are trying to take those first few steps to get back on their feet from being able to do that.
Yeah, and as we'll talk about, it also deprives people needing of help, like counseling, from working with people that have been through it and survived it and made really great changes, which we hope they ultimately do. So with that, tell us a little about your case. Tell us a little about your client.
Sure. So that barrier law, as it turns out, according to the Virginia's Department of Behavioral Health and Developmental Services, the agency that administers it, actually ends up keeping out people with invaluable experience, hundreds of them every year, because of convictions that are more than 20 years old. And the reason for that is that people who want to go into substance abuse counseling, who want to work in rehab centers, help people who are struggling with drugs or alcohol, have often been there themselves. A lot of those people have these problems when they're in their teens, when they're in their 20s. They get cleaned up, they get sober, they turn their lives around, and then they realize that like they could spend the rest of their life helping other people because they have that same experience, that they are in some sense the best suited to be able to help because they can say, I've been there. But because of those struggles with drugs, a lot of them will have old convictions from when they were maybe stealing to feed the habit or something like that. And so what ends up happening is that even though addiction is, like a declared public health emergency in Virginia, and there's a shortage of qualified counselors, this law is on the book keeping out people who want to help because of their old convictions. And one of the particular examples of that was my client in this case, a wonderful woman named Melissa Brown. And she did struggle in her 20s. She had problems with drugs. And one day...
Hey, folks, sorry, I had a bit of a technical difficulty and my computer just crashed. So we're going to kind of restart the discussion. So Andrew, I apologize for that. You are telling us about your case and about your client. So why don't we start from there, and then I'll just edit it out. So does that work?
Sure. So one of the people who really exemplifies that problem of qualified people being kept out by old convictions, by this barrier law, is the plaintiff in this case, my client, who is a wonderful woman named Melissa Brown. Now, decades ago, she struggled with drugs. And in 2001, when she was in her 20s, she went up to a stranger in a Food Line parking lot and snatched that woman's purse. Now, because of that, she was convicted of robbery. She did a few years in prison, and she changed her life. She got cleaned up, she got sober, and as is this common story, she realized this is something she could really take to then use and help other people. So she started working at a halfway house. Then she started working at a treatment center. She eventually got even promoted to the lead supervising substance abuse counselor. But it's unclear exactly whether this was legally allowed or not, because there might be some difference between employees and independent contractors. But regardless, new management bought the facility. And when new management reviewed the employees, they said, hey, wait a minute, you should have never been here. You've got this barrier conviction from 2001. And it doesn't matter that you've been working since 2014. It doesn't matter that you've been doing an excellent job because of this thing on your record from, more than 15 years ago. It seems like the law says you can't be working here. So she was fired.
And I did have a question because I saw that in the opinion, the difference between employee versus independent contractor. What can you just tell me why that mattered and how that came into play?
It looks like, as just a matter of like quirky statutory drafting, the law at first didn't apply to independent contractors, only to employees. And so the department was actually trying to help people get around the law by saying, be hired, not as an employee, as an independent contractor. Eventually that changed. And now it applies to both. But in any event, she was removed from this position because they thought it was illegal. And once she was removed, it certainly would have been illegal for her to go back into it because she had that barrier conviction. She stayed in the industry as best she could. She transferred to sort of different marketing roles, but what she always wanted to do was getting back to helping people and using these skills that she developed after years. I mean, she went back to school, she got a degree, she did thousands of hours of hands-on clinical training, and she wanted to get back to using those skills so she could help other people.
Yeah, and one question I do have, and maybe you don't know the answer, but when I hear somebody's convicted of a robbery, a violent crime, and this is really a purse snatching case, it sounds like the underlying crime, unless I'm misunderstanding it. I wonder how that didn't was. Do you know if there was any effort to avoid that felony conviction there in the underlying case? Did she go to trial? Or what was like the procedural posture before the conviction?
Well, I don't remember. I don't believe she went to trial, but it implicates what we were just talking about, that people don't think, even sometimes lawyers don't know about these collateral consequences that can happen years or decades later. And it's also something that judges have noted in reviewing these sorts of laws, that there is, to like a clear-eyed observer of the criminal justice system, like maybe a different lawyer, maybe different plea bargaining, maybe a prosecutor who didn't wake up on the wrong side of the bed that day. Maybe you have some slightly different conviction for the same conduct, and that's all the difference between whether you're totally allowed to work or whether you're banned for the rest of your life. And that contributes to the irrationality of these laws.
Yeah, and I can tell you, as we sit here today, if I'm in one jurisdiction versus another, if I'm in one prosecutor versus another, if I've got a one judge versus another, that case has a very different outcome. They have vast implications. So I really appreciate the efforts you're making there. The Department of Health, I was a little confused. Why is it that they're the ones defending this law as opposed to the Attorney General? And was there ever any discussion with them about, do you guys really want to keep her from working, this person from doing this important job?
So a few different things there. There are many sort of comparable barrier laws in Virginia, and there is one for the Department of Health. This one is implemented by the Department of Behavioral Health and Developmental Services. Yeah, and they were, the commissioner was the nominal defendant, and it was defended by the AG's office because their job is to make sure the government gets to do whatever it wants. But what is the department's position? I mean, we have in writing from their testimony before a subcommittee that I believe you were a part of, that this law keeps out people with invaluable services. With invaluable skills. And in fact, the woman who administers the law testified in deposition that applying it in these kinds of circumstances is, and this is a direct quote that definitely made its way into the briefs. Direct quote, crazy.
Okay. And I'm glad that's part of the record. Because when I look at that and I think about, what is the power of the governor? What is the power of any particular prosecutor? There are crimes that can be prosecuted. There are statutes that are on the books that can be defended by the Attorney General. And I'm just wondering if there was any discussion with the Attorney General saying, look, maybe this is something we shouldn't be pushing. And was there any of that discussion, or was it just, hey, look, this is our job and we got to do it?
Well, I mean, we've had every opportunity. I mean, there have been two lawsuits. We don't really need to get into that. The first one went away for quirky procedural reasons, but we've been litigating at this for years. I would have loved to have had them say at the get-go that, this isn't something that really we need to be defending, but that's not what happened. I think it's their responsibility to make sure that, the government has all the powers it could possibly have, and that's how it was litigated.
So let's get into a little bit of the weeds about what claims you made and what were the basis of those claims to get around to say the law should not apply here.
Yeah. So we, as my firm typically does, we basically brought two versions of the same claim. Looking at it under either substantive due process about the right to earn an honest living, or equal protection, discriminating between people, who have been convicted of these barrier crimes and who haven't. Either way, under the 14th Amendment, the law has to at least be rational. The government can't do totally crazy things. And at least as applied to this person in this case, a law like this is just totally irrational. No one could possibly think that preventing, this like grandmother in her 50s who has done nothing but train for decades from being able to help other people is actually keeping those very same people safer.
What did the AG argue? Because obviously they were defending the law. What did they argue the rational basis was for it?
Just a general sense of, she's bad. She's been convicted of robbery. We can't really trust her. These are people who are struggling, and so we need to make sure the people around them are high quality people. Honestly, there was a certain tone to their briefs of like, robbery was a felony at common law. You're lucky we didn't have her put to death. But
what about an oral argument?
That's my gloss. They didn't say
that, really. What about was there oral argument, or was it on the pleadings?
No, there was an oral argument on the motion to dismiss, and then later on the motions for summary judgment.
What was the tone about her behavior from the AG in the room? Was it the same kind of tone, or was it?
I mean, a little bit. I mean, of course, you can have them on the podcast and ask them what they.
Well, I doubt they're coming on, but
I mean, the idea is, look, the rational basis test means the government gets to do whatever it wants, no matter what, and this is our prerogative. And frankly, maybe she hasn't fully taken responsibility. She said something in deposition that she doesn't think about her criminal sentence anymore. So, how can we,
Well, I mean, I think if I'm working for the AG, what is my argument here? The argument is that the legislature, through its deliberative body, has elected representatives and had arguments on this, considered whatever data and whatever arguments, and decided this is law, and they haven't changed it. And so the rationality is you've had the people come to speak, and this is what they've spoken. Was that argument articulated?
Yeah, pretty much. And I mean, that's the basic idea of the deferential rational basis test. By and large, we trust democracy to work. It's not the place of the courts to step into that. And that's how oral argument started. When we first got before the judge on a motion to dismiss, she said, look, this person is very sympathetic, but isn't this just something you need to take to the legislature? They do sometimes change these laws, and who am I, a federal court, to step in and interfere with democracy in a state?
So what did the court, what issues did they ultimately rule in your favor, for and against, and kind of tell me about how that came down?
The court ultimately ruled in our favor on equal protection grounds, saying that there were just so many different exceptions in the law that it can't possibly be rational to prevent this plaintiff from receiving the benefit of that. One of those was grandfathering, that if you were working before the barrier law was enacted in 1999, no problem, keep working, even if you're some supposedly totally unsafe, criminal. And the other was this idea of screenings. Now, most of those 176 convictions do result in a lifetime ban, but some of them, you get to go into these screenings where a mental health professional, will basically assess your rehabilitation. And if you're lucky enough to have one of those convictions, you sail right through. The screenings take an hour and a half. They have a 96% pass rate. And like, which crimes can get into that screening and which can't are just totally inexplicable. It's not seriousness necessarily, because higher level felonies than a simple robbery, which is, a sixth level, the least serious felony, can still be screened. It's not about violence necessarily, because certain violent crimes can be screened. And so even burglary, for example, can go into those screenings. If Melissa had been convicted of burglary instead of robbery, she'd be eligible, and then she'd sail right through. And in fact, one of the very few providers in the state who administers those screenings was a witness in the case. Putting in a declaration saying someone like this is basically going to pass. And you know what? On top of that, that guy was himself convicted of felony burglary, the person that the state trusts to assess whether the other people are rehabilitated. And when you have a record like that, there was just no possible conceivable reason that keeping out another qualified person, when she would clearly pass the screening, if only she could get into it, there's no way that was rational in a way that comported with equal protection.
Yeah, and unless it's lost, and it may not be lost in the audience, but just to be clear, robbery in Virginia is taking a property with some force. I've had represented juveniles that have been charged with robbery because they were trying to bully some kid and took his phone from him and threw it in the toilet, and that was robbery, right? So when we hear the term robbery, it can mean a lot of different things. So I think that was important. And so what did the court here ultimately say she needed to do? Because I think that if I read it correctly, it was about essentially allowing her to be screened. Is that what ended up happening?
Yeah, that's right. So the court issued a final judgment just last week, saying that the Virginia government, DBHDS, had to let her proceed through one of those screenings and allow her to work if she passed.
One thing that you just pointed out that I wasn't aware of is you said this barrier crime was just passed in 1999. Is that right?
That's when it first went into effect.
Is that the entire frame? Because I even though I was on that work group or committee, I wasn't aware. Nobody ever brought that up to me when the laws actually came into effect. Is that a majority of that framework that was 1999, or was this just this specific aspect brought up?
No, the basic idea and framework started in 1999. It's been tinkered with since then, adding certain exceptions when the right person who knows the right state senator gets something in. It's really idiosyncratic. I mean, there are these very specific exceptions that if you've committed the one crime of assault and battery on a public official, for that one, you can get into the screening if it's been 10 years and you have a gubernatorial pardon. But of the 176, that's the only one that has to do with a gubernatorial pardon. It's not the most cohesive framework. Did you guys look at kind of what was the, I guess maybe political culture, or what was the spawning of barrier crimes? Where did this? We don't really know. I mean, I think I could. Not about this law, but broadly speaking, a lot of these laws either date to the first professionalization of an occupation in the 30s, 40s, 50s, where they just threw in language about sure, felonies are bad, good moral character is good. Put that in the text. I think other ones are responses to certain events where, unfortunately bad things happen in the world, and then the legislature comes in and puts in something really sweeping that might be counterproductive, but it's not like people with felonies are, a concerted interest group that have the ability to oppose things.
Wow. In Virginia, they're not even allowed to vote unless you get your voting rights. And I guess the 90s is, the war on drugs, and everybody, even Democrats are getting elected on tough on crime, and, the mass incarceration starts. So I guess it just kind of a trickle down from that.
Exactly. Can I say that? Absolutely. Another thing about Melissa is not just that her rights were restored. It's also that she went to go and become a state certified substance abuse counselor, which can be prohibited based on felony record.
Yeah.
And that was granted. Virginia said she was fit to do it despite her criminal history. It's just that there was then a separate law saying, but you are prohibited forever from actually doing it.
When
if you want to talk about irrational,
when she started down this road of this is what I want to do, was she ever I guess because she was fired, she never knew that this was an issue until it was an issue, right? She had no idea.
That's exactly right. And that's one of the huge problems with these laws, just more generally, that people will go, they will spend the money that can be a lot of money for somebody coming out of jail in an entry-level profession, that they go and they get the training, and only then do they find out that there's going to be some problem. I mean, there are states that have these sorts of restrictions for occupations that are taught in prisons.
Wow.
So, you learn the skill, you think you can go do it. California famously uses inmates to fight wildfires and then prevents them from becoming firefighters based on the criminal history that put them there when they were a firefighter.
Wow.
Yeah.
Wow. What is the reaching effect of this opinion beyond your case? Does the court just say, look, in this one instance, this is what the rule is, or is it going to have a broader impact?
So formally, it's narrow, right? The result applies to her. That's what the judgment is. But some of the court's reasoning about grandfathering, about comparing somebody with one conviction to somebody with a different conviction who could get screened, that's broader. Your listeners will, of course, know that no district court opinion is binding precedent in federal court. But, I'd like to think it's an excellent starting point for inspiring some change, or if not that, then future lawsuits.
Do you expect the Attorney General to appeal the decision? Have they given you any indication?
I have guesses. I have no actual idea. They
Okay.
haven't. They've got
Yeah,
until
'cause
October 30th.
yeah, this just, I mean, we're literally within the window of appeal as you're talking. Hopefully I'm not getting you in trouble for letting you talk about it this early. What is what's Melissa's plans going forward? How is she feeling? Tell me about that.
I mean, she's thrilled. She was so happy when she heard
Yeah.
the news, and you know, judgments are effective pending appeal unless they're stayed. So she's going to go get to work.
How does it feel to be you and your team? Like, what's going through your guys' mind?
I mean, it feels pretty good. You know, it's as opposing counsel pointed out, these cases are pretty hard for plaintiffs to win. So when you go and you can actually do it, I mean, it feels pretty good. And of course, you know, it's not really about me and getting a pat on the back that we litigated well, like being able that we got somebody, you know, help for her about her being able to do the work that she finds meaningful, and that in turn is going to help other people. That, I mean, of course that feels great.
So I suspect that at least a few of my friends in the legislature may be watching this. Or may watch it. I don't know if they'll get all the way through this far, but assuming they are watching, would you have any suggestions for them about how they can improve the law to make it to where these lawsuits aren't needed?
Yeah, I mean, I think the very simplest, easy way to go is just make the screenings across the board. You can still keep out, you know, anybody that you think is genuinely going to be dangerous, but you know, if you can look at a person and determine like, yes, this person's going to be helpful, then that's a great first step that would go a long way towards solving a shortage that everybody acknowledges.
Yeah, talk about that. What is, to your knowledge, what is the shortage? What is the need? And let's talk about substance abuse specifically, since that's the case you're dealing with.
Well, I mean, you know, I mentioned this earlier. It's the official position of the Youngkin administration that addiction is a public health emergency, that there is a shortage of counselors, and we have material on that in our brief. You know, everybody who was a witness talked about, you know, there are not enough people working here. We cannot fill our beds because we don't have enough people to treat them. My caseload is at record high numbers. It's a problem. And then there's this whole pool of people that are qualified, that are trying to work, and letting them in is going to help.
You know, I can't help, and I try to on video. I'm very critical of this administration, but I try to be as productive as possible. But I can't help but think, if the Youngkin administration's position is we have a shortage and we have a need, and you have a case like this, wouldn't the time and money have been better spent to work with the legislature to get barrier crimes reform, rather than spending money litigating this case and defending it as is?
That makes sense to me, but you know, I'm not an elected official. I don't know what they say.
Sure. Is there anything else about the opinion that you found compelling, whether it was words by the justices or things that you think need to go forward, cases that you'll be looking at, anything that I haven't really asked you about that's going through your mind right now?
Well, this might be a rather obscure and sort of nerdy point, but for the litigators out there in the audience, something that really struck me came in actually the motion to dismiss decision, where, you know, the government had argued so thoroughly that, like, look, this is rational basis. We get to do whatever we want. And if this is the wisdom of the people of the Commonwealth, then that's going to be the law. And the district court wrote in response that, you know, that's not right. Rational basis review is a form of review. So it has to mean something beyond absolute deference to the government, because then it wouldn't be review at all. You know, it's still a real constitutional standard that plaintiffs can win under. And maybe that's not the most emotionally compelling point, but it really mattered to me as someone who brings these sorts of cases that, like, yes, they might be hard, but it's also the case that plaintiffs do win them.
Yeah, and you know, just thinking about that, and Seeing, I've been practicing 16 years. I've been working with the legislature a bit. We all kind of see what's going on the national level, how laws are passed, how the legislatures work. A lot of times things that get passed end up being the end bill becomes very different than what the intention was at the beginning. So the court's ability and actual job to take a look at the impact ultimately is so important. What's your thoughts on that?
Absolutely. I mean, with all respect to our tripartite, system of government, I do not think it is the case that every branch carefully scrutinizes the constitutionality of its actions. And if people in the legislature are not looking at, is this law constitutional? Is it so broad that it's unconstitutional in many respects? Then it has to be the job of the courts to say so.
Yeah, and look, I really appreciate you doing the work, man. I mean, I sit back and admire all that your office does, and it's just like, that looks like it's just you guys are having fun and doing important work. Tell us a little bit more about folks needing help. Like, who are the folks that should be coming to you that you think you can help out? I know you have, it looked like the Fresh Start Practice Group, which I thought was a clever name. What kind of people are you looking to help out? Who should be calling you?
That name was my boss's idea, so he'll be pleased to. I'll let him know. He'll be pleased to hear it. I mean, I think that it's not just these criminal history cases. This is what my firm does. If you think that the government is preventing you from working for a reason that just can't possibly be right, because of something that you did 30 years ago that has nothing to do with what the work you're trying to do, or because in laws that we encounter in other ways, because your competitor is already doing it. Somebody with more political power already opened a business, so you don't get to do it too.
Yeah.
If you're doing something that's absolutely harmless and that the government just says, no, that's not allowed, we'd be happy to hear from you. www.ij.org.
www.ij.org. I'll definitely put it in the show notes. I'll also put your bio in there just so if folks want to contact you, learn more about you. Any interesting cases that before I let you go, that you think we should be paying attention to? That you're working on? And you're allowed to talk about.
Well, the other big thing that I'm working on these days is this crazy thing about federal financial surveillance, where the Treasury Department tried to get people to do like 30 new hours of paperwork every day just to spy on people near the border. But it's probably not germane to this, but it's a thing. And if you look up my profile, you can read all about it. I think the bottom line is that we've now sued in 3 different simultaneous cases. Every single one of those judges has issued a temporary restraining order and then converted it into a preliminary injunction because of how blatantly unlawful this program is. It's a fun time.
Well, that's it's fun. It's scary times, but a fun time. You guys, you get your funding from contributions, right? Is that how you get your money to be able to do the work?
Yep, just people who think we're doing a good job.
Yeah.
This is relevant to our discussion. I will say, every once in a while, there is the only money we get from the government, which is attorneys.
Okay. Well, if you are watching this and you're interested in their work, and let's say you got a little money to throw away, throw their way. I'm sure you guys wouldn't mind that. It's lawyers, especially in these times, that are doing work that really, I think, matters. And so, Andrew, I really appreciate your time. Appreciate the work. Congratulations to you and your client. That's super exciting. And I, as a lawyer, a criminal defense lawyer here in Virginia, I am glad personally that you guys have made change in our law, a positive advancement. I hope it spawns even more change. So appreciate your work, man.
Hey, well, thanks so much, and delighted to be here.
Yeah, stay on. I'm going to end the recording, and then I'll bug you. All right.